Hello everyone, so today we're talking about regulation of participation in private clubs in high school and college athletics. So private clubs are designed to be exclusive with regard to membership, but this exclusiveness can result in unfairness in access to sport for women and ethnic minorities. High school and college athletic programs create opportunities for people of diverse backgrounds to join together as equals in the pursuit of common goals. They also create opportunities for discrimination to occur. Participants in interscholastic and intercollegiate athletics may face discrimination on the basis of gender, including sexual harassment, race, and disability, as well as unfair treatment based on expression, whether religious or political. Student-athlete behavior with regard to sexual activity, drug and alcohol use, and other delinquent conduct is often regulated by coaches and schools by means of good conduct rules. When efforts to regulate conduct are extreme, they may violate athletes' individual rights. This chapter discusses discrimination on the basis of race, sex, sexual orientation, and disability in the context of private clubs and places of public accommodation. Additionally, it explores sex, race, and disability discrimination in the context of high school and college athletics. It also discusses other legal issues raised by regulating participation in interscholastic and intercollegiate athletics, including discipline issues, transfer rules, drug testing of athletes, and violations of dress and grooming codes. Now, these are the management contexts and legal issues pertaining to regulation of amateur participation in private clubs and in interscholastic and intercollegiate athletics, with relevant laws and cases. So we'll be looking at private clubs, Title II, as well as Section 1981 and Section 1983 in public accommodation. With high school and college, we're looking primarily at Title IX and Section 504 of the Rehabilitation Act and ADA, as well as Due Process Clause, the Fourth Amendment, the First Amendment, and the Equal Protection Clause as well. So, what are your thoughts? Do women and minorities have a legal right to membership and all associated privileges, or does a club have a right to exclude groups or limit membership? Some country clubs continue to admit women as restricted members without full voting rights or limit their access to the golf course or tennis course to weekdays so men can have the prime weekend times. They may also restrict women's access to the grill or bar. The issue for members of ethnic minority groups and for women is whether they have a legal right to membership and all the privileges associated with it, or whether a club has the right to exclude them. Some areas of possible discrimination are race, gender, sexual orientation, and disability. We'll be talking about each of these. In regards to race discrimination, in cases where access to country club is denied on the basis of race, a plaintiff may sue under Title II, Section 1981, or Section 1983 of the Civil Rights Act of 1964. Title II of the Civil Rights Act of 1964 prohibits intentional discrimination on the basis of race, color, religion, or national origin in places of public accommodation. To prevail, a plaintiff must prove discrimination on the part of a place of public accommodation, which is defined as to include places that affect interstate commerce and are facilities principally engaged in selling food for consumption on the premises, as well as sports arenas, stadiums, and other places of exhibition or entertainment. There is a statutory exemption from the requirement of Title II for private clubs. Sports facilities are places of entertainment under Title II because the Supreme Court has found that both direct sport participation and spectatorship are entertainment. At issue is whether a private club is a place of public accommodation, and is the club truly private? To determine if a club is truly private, you can use the Lansdowne factors. Now, you must prove 3 of 8 of these factors to evaluate their private status. Number 1, genuine selectiveness regarding membership. Membership control over operations. Look at the history of the organization. And what kind of non-member use of the facility is allowed. and the purpose of the club's existence, as well as advertising for new members, organization as a for-profit or is it a non-profit, and what formalities are observed. Now, other sections of the Civil Rights Act, Section 1981 of the Civil Rights Act prohibits intentional racially discriminatory acts in the making or enforcement of a contract, like a membership contract. There are no exemptions for private clubs in this section. Under the Section 1983 of the Civil Rights Act, plaintiff must allege that a right found in Constitution or other federal law was violated and that the person violating the right was engaged in state action representing state or community government. As far as gender discrimination, sex is not a protected category under Title II. Plaintiffs that bring gender discrimination statutes claims must rely on Section 1983 of the Civil Rights Act or state public accommodation statutes. Those state public accommodation statutes actually are broader in scope than federal anti-discrimination laws. The state statutes protect people in a range of categories including sexual orientation, marital status, age, and disability. There are other forms of discrimination, such as several state and city human rights laws prohibit discrimination on the basis of sexual orientation, as well as the usual protected categories. Now, sexual orientation, there's a possible defense that a club could use that a private club is engaged in expressive association under the First Amendment. As far as disability is concerned, Title III of the Americans with Disabilities Act protects people with disabilities from discrimination by private entities operating as places of public accommodation. To analyze a Title II claim, the steps are as follows. Does the individual have a covered disability? Does that impairment substantially limit a major life activity? And number 3, was the individual discriminated against solely on the basis of that disability? Now, some competitive advantage strategies for participation in private clubs. If you are operating a club that is truly private, examine cases that apply the Lansdowne factors and structure policies accordingly. Avoid implementing restrictive policies. Be aware that a truly private club may not be subject to legal challenge, but is subject to negative publicity. And plan for inclusion of athletes with disabilities in all programs and services where feasible. And make sure to educate your staff. Now, legal issues related to participation in high school and college athletics. Many laws are implicated by efforts to regulate participation in high school and college athletics. Gender equity, discrimination based on race, disability, or religion, discipline issues, transfer rules, drug testing, social media, dress and grooming codes. With gender equity, really what we're looking at is Title IX. Now, this was passed by Congress in 1972 as a remedial statute that is intended to address sex discrimination through education and not just in athletics. The results are more than 3.2 million high school girls participated in athletics in 2011 and 2012. 43% of intercollegiate athletes were female in 2011 through 2012. However, inequities still exist. Now, in the enforcement process, remedies, and regulations, one may file a claim with the United States Department of Education's Office for Civil Rights, or OCR, which then must investigate. Now, there could be monetary damages and injunctive relief awarded. There may also be punitive damages as well. Discrimination must be found to have been intentional, and if found guilty, schools would completely lose its federal funding, meaning losses of millions of dollars for some universities that receive research dollars from large federal grants. They do have to evaluate the program as a whole. Now, failure to provide adequate resources for one item in the list of athletics benefits and opportunities, such as publicity, as long as the overall negative effect program-wide is negligible. It might also mean providing inequitable facilities or scheduling of competitive seasons when the inequity was deemed substantial enough to deny equal opportunities to the participants. It could be also failure to provide scholarship dollars to female athletes in proportion to the percentage of athletes who are female. And might also affect participation opportunities. Still, again, there are some areas of inequity. Now, participation opportunities focus is mostly on Title IX legislation. There is a three-part test for compliance that was based upon the Cohen versus Brown University case. And really what they found here is that, number one, numbers should be substantially proportionate to their respective enrollments. In our case, we have about 60% female versus 40% male, and so our sports must be proportionate with that. Number two, members of one sex have been and are underrepresented among intercollegiate athletes. It looks at history and continuing practice of program expansion responsive to the developing interests and abilities of the members. So one of the things that has just come about recently is the addition of women's soccer and the beach volleyball. And again, that is respective to our numbers of enrollment. They had looked at football, and with football, that requires a larger number of male enrollment, and we don't have that. And so they did a big, long study, and they basically came up with the idea of the soccer and also the beach volleyball. Beach volleyball was something that was very inexpensive. We already have volleyball players. Really, we just needed a facility. Now, with the soccer, we did have to, of course, build a facility for that, but we were able to also roll that into not just a facility for soccer, but also a facility for track, which we did not have. So it kind of helped in that purpose. Number three, an institution cannot show a continuing practice of program expansion. Now, other issues in gender equity: reverse discrimination. In this particular case, it would be by the underrepresented gender as such, and oftentimes it's claims by male athletes that the application of a Title IX remedy constitutes reverse discrimination against men, and claims alleging discrimination under the contact sport exemption in the regulations. Now, with contact sports, Title IX regulations require that where a particular sport is offered to one sex but not the other, persons of the excluded must be allowed to try out for the existing team. If there is a men's tennis team but no women's team, a woman who wants to play tennis must be allowed to try out for the men's team. Exemptions are made with contact sports. As far as pregnancy is concerned, individuals may use Title IX to seek a remedy for discrimination suffered due to pregnancy. It is a form of gender-based discrimination. Some athletic departments have written policies informing student athletes that they could lose their grant and aid if they become pregnant. Some competitive advantage strategies in accordance to gender equity. Consider adding a women's sport or elevating it to varsity status if there's an interest and ability. Consider alternatives to dropping men's sports when moving toward compliance. When boosters or alum give money for a single-sex sport, purchase something comparable for the other gender's program. And remember that Title IX applies to clubs and intramurals as well as to varsity sports. Some other competitive advantage strategies: make sure that the gender ratio of dollars spent on grants and aid mirrors the gender ratio of athletes. Conduct training seminars for coaches and players to help them avoid sex discrimination behaviors. Invite Title IX consultants to assist with program evaluation and development of compliance strategies. Reallocate resources equitably by identifying ways to reduce unnecessary costs. and plan ways to increase resources for sports for women, including corporate sponsorships. Now, sexual harassment and abuse. Title VII legal theories underlie quid pro quo and hostile environment sexual harassment claims, which we talked about in Chapter 7. Now, sexual harassment that occurs in an education may also be litigated under Title IX. Sexual harassment that occurs in an educational institution may be litigated under Title IX. The Supreme Court has upheld the use of monetary damages. The possible growing trend of sexual harassment lawsuits against coaches is growing. And so for OCR enforcement of Title IX, actual knowledge of harassment is not required. A school must take corrective action if a student-on-student harassment is creating a hostile learning environment. Anyone may report harassment between a student athlete and a peer or a coach to the appropriate school official to put the university on notice. Some other things that occasionally happen are travel to other countries, and this is, in other countries, the drinking age is 18, and so the likelihood of inappropriate sexual conduct increases with excessive alcohol consumption. Now, in 1990, the Jean Cleary Act required college officials to report incidents of sexual assault. Some competitive advantage strategies to avoid sexual harassment claims. Develop, implement, and publicize a sexual harassment policy that includes a reporting and appeals process. Remind all constituents that sexual harassment is not just an issue of men harassing women. Establish a reporting procedure that encourages those who witness sexual harassment to report it. And investigate allegations of harassment promptly. I think this is something that we saw with Baylor. Investigating it and reporting it and following through on it. Remind athletes and coaches that on-campus policies also apply when they are traveling. Now, race discrimination. Racism is subtler than gender discrimination and may be more difficult to prove. Very little litigation is brought by student athletes. And plaintiffs may bring suit under Title VI of the Civil Rights Act of 1964, which states no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. Some competitive advantage strategies for race discrimination. Avoid establishing eligibility standards that place a lot of weight on data that may be racially based or biased, such as standardized test scores. Distinguish between a policy that has a negative effect on members of an ethnic minority group because of their ethnicity and one that does so in spite of their ethnicity. Looking at disability-based discrimination. You can ask these questions. Should an athlete with a disability be accommodated? What kind of accommodations are reasonable? And what constitutes a disability? Lawsuits have been filed under Section 504 of the Rehabilitation Act signal a new era in which the courts to recognize that overprotecting athletes with disabilities did not comport with the intent of the disabilities laws, which to support the idea that individuals with disabilities are entitled to live as full a life as possible, and that would include physical or learning disabilities. Now, they can also file claims under the Americans with Disabilities Act. At a legal analysis under Section 504 and Title II of ADA, the plaintiff must prove that he or she is disabled and is otherwise qualified and has been excluded solely on the basis of disability. To prove that he or she is disabled, the plaintiff must prove that he or she has a physical or mental impairment which substantially limits their abilities in one or more of their major life activities. As far as learning disabilities, these learning disability difficulties are a challenge for courts. There are eligibility rules for athletes. One of those is age limit. And so with age limit, oftentimes what happens if they have a learning disability, they've been held back for maybe a number of years. And typically 18 is considered to be a limit for many of those. And so looking at that, looking at the longevity rules that limit the number of semesters of eligibility and their academic standards. So a case-by-case analysis is required, not an undue burden, and is necessary to enable a court to determine whether a waiver in the individual case would work a fundamental alteration in the competitive sports program. Now, Title III of ADA, lawsuits against private entities that own, lease, or operate places of public accommodation. So these are, with Title III, you'd be looking at private entities. And they are primarily used against the NCAA as it is a private entity. It does not necessarily have a place or facility of its own. So the NCAA is a big organization. It does not necessarily have a place or facility of its own. The individual schools have the facilities. And one particular case with PGA Tour versus Martin in 2001, the PGA Tour operates as a place of public accommodation. And so with that, there were some fallout associated with it. Now, the NCAA is a private entity. It operates as a place of public accommodation. So the NCAA exerts control over access to participation through its eligibility requirements and requirements of compliance with its other rules. Now, athletics teams for participants who are disabled. Are high schools and universities legally obligated to provide separate teams for athletes with physical disabilities? No school has yet created entire teams of people with disabilities and fully supported them as varsity teams. Some universities are beginning to provide such opportunities, though. I really see this as something that will be growing in the next few years. You're seeing it in the community sector, and I really believe that with you've got your wounded warrior. I think that this is something that's going to grow. So something to maybe think of it later on. Some competitive advantage strategies for disability discrimination. Consider offering special teams for people with disabilities. Assess each request for accommodation individually. And establish internal complaint procedures for resolving ADA and Section 504 disputes. Another thing to think about, too, is that there's actually a lot of grant money available for making accommodations for those with disabilities. So just a thought. Discipline issues. Athletes are subject to disciplinary penalties when they violate school rules. There are also conduct rules. And these conduct rules often are challenged for unfairness. The law of private associations, arbitrary and capricious standard, and their eligibility for participation. So with this, one of the rules that, especially in high school, is the beer rule. The beer rule that you are consorting with others who are drinking. So that's a big conduct rule in some high schools, and so that is something that is being challenged, and is being challenged under the Due Process Clause as well as the Equal Protection Clause. Now, the Due Process Clause says that athletic participation is a privilege, not a right, that is protected by the Due Process Clause. There is protected property interest in an athletic scholarship or a liberty interest in one's reputation as an athlete. Under the Equal Protection Clause, there are disciplinary rules that have been challenged, and athletic participation is used as a rehabilitation tool for delinquency or as part of a required individualized education plan for students with certain disabilities. Some transfer rules. Transfer rules regulate the circumstances under which athletes may transfer to other high schools or colleges. Some high school rules regulate school districts that might try to entice an athlete to move. And transfers should be based on reasons other than athletic competition. Some college rules attempting to ensure competitive balance. A student who transfers from one four-year college to another is prohibited by NCAA rules from participating in athletic competition for a year, but this restriction may be waived under certain circumstances. With drug testing, it's widely perceived that there is a drug problem in school sports. Performance-enhancing drugs or supplements. 2.7% of high school seniors have used steroids. This is according to a survey in March 2007 of California high school students. There were 283 males and 203 females. In another study, the NCAA in 2009 surveyed 20,474 student athletes and found that while 83.1% reported having used alcohol, only 22.6% used marijuana that year, and 3.7% had used amphetamines, and 0.4% reported use of anabolic steroids. Now, there are reasons to test for drugs. One of those is the protection of health and safety of the athletes, and to make sure that there is a level playing field. You also want to make sure that you're protecting the integrity of the contest and ensure that athletes are good role models. Some reasons not to test: invasion of privacy, unreasonable search and seizure, and it's unfair to single out athletes, as well as unfair to force consent. Now, there is random selection for mandatory drug testing, and middle school and high school athletes are minors, which reduces their constitutional protection. And loco parentis, it gives the school extra authority to regulate students because the school is responsible for their well-being in the absence of their parents. So, what are your thoughts on drug testing? Is the loss of privacy worth it in order to ensure the integrity of the contest? The legal analysis of a drug testing search under the Fourth Amendment. In general, the issues in a student-athlete drug testing case proceeds as follows. Number one, was there a state action? If so, does the complaint of activity constitute a search and or seizure? And if so, was the search reasonable? Was it justified at its inception? By probable cause, reasonable cause, exigent circumstances, or random searches based on special governmental needs like airport searches? Was it reasonable in scope? So, number one, did the individual's reasonable expectation of privacy, was that taken care of, and their nature and degree of the intrusion balanced against the government's interest in conducting the search and efficacy of the search in meeting the goals of government? If the search was reasonable, the Fourth Amendment was not violated. Some competitive advantage strategies in drug testing for athletes. Consider whether monetary and privacy costs are outweighed by deterrent value of drug testing. Limit consequences of positive test results to restrictions on participation and requiring rehabilitation, and avoid criminal enforcement. Make sure to maximize anonymity and accuracy in sample collection, testing, reporting, and data storage, and provide opportunities for retesting to verify positive results. Some expression issues. Sometimes student athletes are subjected to discipline for engaging in expressive activity, such as wearing their hair, clothing, or tattoo in such a way as to violate or grooming or dress code, or posting prohibited content on social media. Due process clause or First Amendment right to freedom of expression or freedom of religion. Failure to comply with rules can be used as grounds for suspension from team or school. Students have challenged such rules with First Amendment rights, due process clause, and equal protection clause. Now, along with that, some social monitoring services alert athletics department personnel of inappropriate conduct and communication with social media posts. So what happens to student athletes who post content online, prohibited content? And so with that, two companies, they monitor the social media behavior of the student athlete and look at inappropriate conduct and eligibility issues. They also look at and possibly ask student athletes for disclosure of their usernames and passwords. Much of that is application to be installed on each account to be monitored and monitoring publicly available information. There's codes of conduct and use on social media, and bans on use of social media may be in violation of First Amendment protections, freedom of expression, and the due process and equal protection clauses. So, do you use social media sites such as Facebook, Instagram, Twitter, and others? Have you ever thought that some posts might be inappropriate and could lead to trouble? What do you think of the idea of monitoring services? Do your opinions change if you view the concept from the perspective of an administrator, coach, or even a parent? The freedom of religion, First Amendment, the Establishment Clause, and Free Exercise Clause all have a dealing with freedom of religion. One of those freedoms is, of course, dress code and how it can conflict with freedom of religion with headscarves and modest clothing. Could also be conflicts over prayer before games and after games as a celebratory behavior. Some competitive advantage strategies: creating policies that don't infringe on the Bill of Rights, have a sport performance related objective for dress or grooming codes, and develop a monitoring protocol for social media use, and consider First Amendment limitations on restricting students' speech activity. Avoid creating and implementing pregame prayer policies. If students want to have pregame prayers, avoid censoring